Mr. Regas.
Good morning. May it please the court. My name is Alan Regas. I'm assistant prosecutor in Cuyahoga County. I would like to reserve 3 minutes in rebuttal. Thank you. The case before this court represents, I believe, 2 issues to be determined. This is not a case about whether or not offenses are allied or not. This is a case about what happens when that determination is made at the appellate court. In this case, Mr. Wilson was found guilty of 3 offenses: aggravated robbery, felonious assault, and kidnapping. The court proceeded to impose a sentence for each of those offenses. On appeal, the direct appeal had 6 assignments of error. The first 3 dealt with whether or not he was guilty. Those were overruled. The next 3 raised 3 distinct sentencing issues, one being whether or not these offenses were somehow allied. The next that was raised was whether or not the actual sentences imposed were proportional to similarly situated offenders who committed similar crimes. And the third one was whether or not this sentence that was in fact imposed, the amount of time, was a product of judicial bias. In resolving these 3 assignments of error, the 8th District looked first to whether or not the offenses were allied, determined that the kidnapping would merge into the aggravated robbery and felonious assault, and then found the other claimed errors to be moot. I believe that's the wrong method of analysis in this case. An appellate court has a duty to determine the errors that were raised that are capable of resolution.
Well, they sent it back for resentencing, so isn't that just a total academic exercise if the trial court can only sentence on essentially 2 offenses, right? When it goes back, what are they going to be sentencing on?
They'd be determining whether or not they would listen to the state's election as to which sentence should be imposed here. I don't believe that Whitfield requires a de novo sentencing. And I don't think that when we look at this court's history from 2006 to 2010 in resolving sentencing issues and the scope of us resentencing.
But you want the Court of Appeals to go ahead and do an analysis as to whether the sentence that's not ultimately going to be imposed is excessive. Is that right?
What I want, what was raised here was...
Because that seems like...
If I can back up.
Yeah.
I don't believe that Whitfield requires a de novo sentencing. Whitfield, the error that's been found when there are allied offenses is not an error in whether count 1 had X sentence or count 2 had X sentence. It's the fact that both of those sentences exist. So if there's no error in count 1, in this case, for the felonious assault, there was an 8-year sentence. If that sentence is not found to be an error, and the sentence imposed for the kidnapping itself is not found to be an error, then the only thing that's required of the trial court is to find out which sentence the state elects to proceed on. There is no, without error. If I could go back, in 2006, this court decided State versus Saxon. Looked to what was raised before the appellate court, said, here's the error, address only that error. It also said that sentences are to be looked at individually. They're not part of a sentencing packaging document.
Hey, I'm still not understanding. This is going back. In your view of what the trial court should be doing when it goes back is not permitted in some fashion by what the Court of Appeals did?
The Court of Appeals ordered a full de novo sentencing, threw out what happened at the sentencing, vacated the sentences, and said, listen to the state and proceed to sentence anew.
That means, Mr. Regas, there were 3 convictions, am I correct?
Yes.
Okay.
One was kidnapping,
Yes.
one was felonious assault, and the third was...
Aggravated robbery.
The Court of Appeals made a determination that the kidnapping merged with one of the felonious assault. Am I right?
It did, and as well as
You
murder.
agree with that determination?
I did not raise that before this court.
All right.
I believe that under the facts...
So you don't really object, if this goes back to the trial court, to have the state elect whether the sentence will be imposed on kidnapping or felonious assault, and then the court can conduct that resentencing hearing, correct?
Exactly.
Your objection really is on a different subject. There were two additional matters raised in the appellate court. One is judicial bias in imposing sentence, and the other is that the sentences are disproportionate. The Court of Appeals said, we're not going to review those, we'll let the trial court do it. So your arguments to us are, the Court of Appeals should have ruled on those two issues, and the scope of the resentencing hearing is only limited to allied offense resentencing and not to a de novo sentencing. Is that your position or not?
That's exactly our position here. And we base that on the fact that sentencing in Ohio is based upon the offense. So if we look at
Counsel,
the aggravated robbery...
the first sentence was 25 years, correct?
In total, yes.
Total. It was because they were run consecutively.
Yes.
And in reality, the prosecution, there were allied offenses, and the prosecution should have picked what sentence, what offense to be sentenced, correct? Which would significantly reduce this 25-year sentence, correct?
It could significantly reduce it.
Well, how could it not?
Well, first of all, at the trial court level, the allied offense argument wasn't made. So I would say that we proceeded and believed that those three...
Let's talk about remand. It's back to the trial court. What are the trial courts, what's going to happen in the trial court? The prosecutor's going to have to make a choice, correct?
Yes.
As to what sentence. What's the sentence that can be imposed for that offense?
For aggravated robbery, a 3 to 10 year sentence.
Okay.
For felonious assault, 2 to 8 years.
Okay. And here, the maximum was sentenced, initially, he had the maximum number of years per offense, and they were run consecutively, correct?
Correct, but it wasn't a maximum on the kidnapping, and it was only 7 years.
Okay, all right. So they go back to the trial court. The trial court's not going to be able to do that type of a sentence and run them consecutively again, so there will be a reduced number of years that will be attached to this defendant, correct?
Correct.
All right. So the bias and the disproportionality that was present in the first sentencing will not be present in the second sentencing, correct?
Presumably, that is one of the outcomes.
Okay, so what good would it do for the appellate court to rule on the first invalid sentence as to proportionality and bias? It
would do two things. Number one, are these sentences proportional? If they're proportional, if the 10 years for aggravated robbery in this case, if there is nothing wrong.
They were invalid sentences. They can't even be subject to a proportionality analysis.
There I disagree that they're invalid. What the error in this case is, under Allied, is that there's more than one sentence imposed. I don't see that they're invalid. I don't think that the 10-year sentence on its own is invalid, and I don't think the 7-year sentence for kidnapping is invalid.
Combining them and running them consecutively is an invalid sentence.
Well, I'll say there's two parts, because I think that the first part is that the fact that they both exist is the error. That they're consecutive is an argument of proportionality, is an argument of bias. It's not an argument of whether they're allied. The only error in an allied offense finding under 294125 is that there's more than one sentence. And here the record is capable of review to determine the propriety of the 10-year sentence, the propriety of the 7-year sentence. When we go back, the state elects. In this case, I can tell this court I'll elect that be sentenced on and serve that aggravated robbery sentence. and the felonious assault sentence. I will ask that to be done. But here we have what we're doing if we look at, say, oh, these are allied, and then vacate everything. We're back to that sentencing package doctrine, where we're making the presumption that the court came up with this sentence in total and didn't sentence accordingly for each offense. And I believe in Saxon, this court addressed that. I believe in Evans in 2007.
So you're arguing that the proportionality and the bias argument should have been applied to each sentence individually, not as to the consecutive package.
Well, not exactly. I'm arguing that the record was clear after the sentencing hearing and that those issues were raised at the appellate court, should have been determined at the appellate court. What the appellate court did was, look, oh, these are allied. We're not going to decide that. We're going to give you a do-over. And I don't think you get a do-over to raise new issues. You don't get the second bite at the apple.
Well, what if the court, if the conclusion from this court is, okay, they go back for the allied choice, and then those two issues can be applied to the new sentence, but nothing else gets, it's not a de novo. You don't open up the whole sentencing, you don't start from scratch, you just get your pick between the three and the two that you're going to merge. And you pick, and now you have a new sentence, then those two arguments can be applied to the new sentence, because they're specifically, I think what the Court of Appeals did, it opened everything, as I understand it, and said the whole case is resentenced. You're saying you just go back and pick, but don't those two arguments still apply to the two that you picked?
Well, they apply to the sentence when it was imposed at the sentencing hearing. Those are capable of review. They were raised as error. They weren't moot. In fact, they should be decided first, because if we find that the sentence...
Doesn't the argument change on excessive, depending on whether it's stacked or it's concurrent?
But that's present in the sentence that's given. So that can be determined. Whether or not the proportionality of the sentence imposed here was proper or not, or whether it was improper, is capable of determination. It was raised. In fact, if it's found to be disproportionate, then he is entitled to a full new sentencing. But since there's nothing wrong or nothing found wrong with the actual sentences that were imposed, the only thing wrong here is that there's more than one sentence imposed on the two offenses. So I would say that he's given the opportunity to go have a new sentencing hearing. He now has the opportunity to actually raise the proportionality argument, which he didn't do to the trial court at the first. He didn't suggest any sentences. He didn't notify the court of any proportionality. None of that was raised before the trial court. So what he gets, because the court is later determined to have imposed more than one legal sentence, the error here is that there's two sentences, not that one is wrong or the other is wrong.
What is your solution as to what we should be doing?
I'd ask that this court find that a remand upon allied offenses is limited to the imposition of the state's elected sentence when there's nothing found to be wrong with the sentences that were imposed.
Should we not be remanding this to the Court of Appeals, under your theory, to rule on the proportionality and the bias, and then the Court of Appeals thereupon remands for the allied selection?
Exactly. That's what needs to happen in this case, because the 8th District did not address those errors as to proportionality or as to the error on bias.
So you're asking this court to address the scope of review on a remand on an allied offense determination.
Exactly.
And the scope of that resentencing should be limited to selection of one or the other of the offenses by the state.
Yes.
Is that not clear in the law now, that that's the limited scope of a remand on an allied offense?